in the majority has some very special words for Chief Justice Roberts, which I frankly enjoy, because Chief Justice Roberts' concurrence is absolute sheer nonsense garbage piled on top of a smoking rubble heap of nonsense and garbage. It's terrible. Justice Roberts is basically like, I'm uncomfortable with this and it makes me squeamish, so I'm going to vote to concur, but I wouldn't have if I had another choice, but that, you think I'm making light of his concurrence? It's because it's really, really stupid and terrible. At the time of Roe, 30 states still prohibited abortion at all stages. In the years prior to that decision, about a third of the states had liberalized their laws, but Roe abruptly ended that political process. It imposed the same highly restrictive regime on the entire nation. It effectively struck down abortion laws in every single state. As Justice Byron White aptly put it in his dissent, the decision represented the exercise of raw judicial power. It sparked a national controversy that has embittered our political culture for half a century. The court continues. Eventually, in Planned Parenthood versus Casey, the court revisited Roe, but the members of the court split three ways. 2 justices expressed no desire to change Roe in any way. 4 others wanted to overrule the decision in its entirety. The remaining 3 justices, who jointly signed the controlling opinion, took a third position. Their opinion did not endorse Roe's reasoning. It even hinted that one or more of its authors might have reservations about whether the Constitution protects a right to abortion. But the opinion concluded that stare decisis, which calls for prior decisions to be followed in most instances, required adherence to what it called Roe's central holding, that a state may not constitutionally protect fetal life before viability, even if that holding was wrong. Anything less, the opinion claimed, would undermine respect for this court and the rule of law. Now, as we will see, that sort of logic is going to rear its ugly head in Chief Justice Roberts' concurrence, which is really, I think, hideous evidence of what a bad justice he is. I was one of the few conservatives to oppose his nomination and his confirmation when it happened under George W. Bush, I think for good reason. Paradoxically, the judgment in Casey, says the opinion, did a fair amount of overruling. Several important decisions were overruled in toto. Roe itself was overruled in part. Casey threw out Roe's trimester scheme and substituted a new rule of uncertain origin under which states were forbidden to adopt any regulation that imposed a quote-unquote undue burden on a woman's right to have an abortion. The decision provided no clear guidance about the difference between a due and an undue burden, but the 3 justices who authored the controlling opinion called the contending sides of a national controversy to end their national division by treating the court's decision as a final settlement of the question of the constitutional right to abortion. As has become increasingly apparent, Casey did not achieve that goal. Americans continue to hold passionate and widely divergent views on abortion. State legislatures have acted accordingly. Some have recently enacted laws allowing abortion with few restrictions at all stages of pregnancy. Others have tightly restricted abortion beginning well before viability. In this case, 26 states have expressly asked this court to overrule Roe and Casey and allow the states to regulate or prohibit pre-viability abortions. Before us is now one such state law. And then he goes into the details of the state of Mississippi and their prohibition on abortion after the 15th week of pregnancy, which is significantly before the viability standards set up by Roe and by Casey. The court says, we hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion. No such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. Okay, so, as we will see, this particular area of the majority opinion is going to be warred upon by Justice Thomas in his phenomenal concurrence. Okay, because what the court basically does here is they say there's still such a thing as substantive due process. Okay, now, the 14th Amendment to the Constitution says that you cannot remove somebody, you can't deprive somebody of their life, liberty, or property without due process of law. Now, when you read that phrase, what you hear is, I can't just come over as the state and seize your property without going through some sort of court hearing, right? There has to be a due process of law in which you get to defend yourself, in which we get to adjudicate the claim, and then we can remove your right to life, liberty, or property, depending on how that claim is adjudicated. That's what due process of law means. The court, actually starting in the hideous case of Dred Scott v. Sanders, which tried to establish the idea that Black Americans actually were not citizens of the United States and could not be. In that case, the court relied upon the idea that due process did not mean there had to be an adjudication. It meant that unless the court decided it was a good idea to deprive you of life, liberty, or property, it couldn't be deprived from you. And they called this substantive due process. Now, as you might imagine, it is oxymoronic that the phrase substantive due process is process, substance is substance. They're not the same thing. But the court here declines to overrule the idea of substantive due process and instead says substantive due process protects rights that are otherwise deeply embedded in America's history and tradition. And so they're going to rely on history and tradition. As we'll see, Justice Thomas would just say, no, that's not the way any of this works. Substantive due process should be cast out entirely. We'll get to more from the majority opinion, the stunning and correct majority opinion from the Supreme Court of the United States. Roe versus Wade has now been trashed. It never should have been ruled that way. We've had 50 years of judicial imposition of complete anti-life tyranny in the United States. That is now over at the federal level. The Supreme Court refuses to overrule the substantive due process interpretation. Instead, they say substantive due process only guarantees rights that are deeply embedded in America's history and tradition. Quote, the right to abortion does not fall within this category. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from any other right that this court has held to fall within the 14th Amendment's protection of liberty. Roe's defenders characterized the abortion right as similar to rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But abortion is fundamentally different, as both Roe and Casey acknowledge, because it destroys what those decisions called fetal life and what the law now before us describes as an unborn human being. Okay, so what the court here is attempting to do is carve off Roe versus Wade from Obergefell, from Lawrence versus Texas. What they're trying to say is just because we're overruling Roe versus Wade, because it is not a right deeply embedded in America's history, doesn't mean we're necessarily going to overrule Obergefell or Griswold or Lawrence. Obergefell is, of course, the same-sex marriage decision. Griswold is about whether a state is allowed to bar the sale of contraceptives to non-married couples. Lawrence versus Texas is about the idea that a state can have criminal laws against homosexual sodomy, for example, right? So those three cases, the court is saying we're not going to touch those. Now, as Justice Thomas says, really, the court should touch those. Really, regardless of what you think of whether there should be same-sex marriage or not same-sex marriage, that has nothing to do with the court. Regardless of what you think about the sale of contraceptives on the state level, that is not the role of the Supreme Court to declare that there is a right to obtain a contraceptive if you are a 14-year-old boy, for example, right? Like all of that is up to the states, is what Thomas would say. But the court is declining to do that. They're saying, we are not going to reopen things like Obergefell. We're not going to reopen Lawrence versus Texas. We're not reopening Griswold. They're explicitly saying that. So when you hear today the left say that the court is going to reopen those things, understand Thomas would, and he would be correct to do so, by the way, legally correct. Again, this is something that the left refuses to understand about the Supreme Court. If I say right now that I'm in favor of the court overruling Griswold because it is predicated on fundamentally bad law, it talks about the emanations and penumbras phrase that was used in Roe actually comes from Griswold. It's a bunch of crap. Emanations and penumbras do not exist in the Constitution. It is nonsense. The court decided in Griswold that it just wanted to create a large-scale right to privacy, not specific rights to privacy from, say, unreasonable search and seizure, but a gigantic right to privacy that somehow covers the public sale of contraceptives. Even if I say I want Griswold versus Connecticut overruled, that does not mean I'm now in favor of legislation to prevent unmarried people from getting contraceptives. I'm not. I think such legislation is stupid. But the left refuses to see, like, as we'll see from the dissent in this particular case, when the left looks at the court, they see a legislature doing what they want to do. So when the right says the court should not be involved in this issue, and then says, even if the court is not involved in this issue, that doesn't mean I'm in favor or against certain legislation. The left fundamentally refuses to understand this. They refuse to understand this. So even if you say, listen, I'm against Obergefell, I think the court should not have gotten involved, and I'm lukewarm on same-sex, like these two things, according to the left, are completely incompatible.